Okay, well, we'll start now. Morning then, everyone. Thanks very much for joining. I'm Chris Brennan, and I lead Gowling WLG's UK procurement practice. Thanks for joining this morning. Happy Wednesday. And today's masterclass is going to be about variations to contracts and the procurement law implications of making changes to public contracts, specifically today as governed by Regulation 72 of the Public Contracts Regulations 2015 as amended. On the 8th and the 15th of November, we'll be running in-house in person, should I say, ThinkHouse public sector sessions. And during those sessions, we're hoping to be able to devote approximately half of the morning to the new Procurement Bill, during which I'll be tackling some of the implications of the bill as it currently looks on procurement contract variations. But for now, today, we're going to concentrate on the existing law, specifically Regulation 72 and how that impacts on changes, variations to public contracts. So that's what today is about. If for any reason a fire alarm goes off in this office, it's for real, so I'll have to leave, in which case we'll simply abort and reschedule the session. Hopefully that won't happen because the fire test was yesterday. So without further ado, let's get on with it. So the whole area then around modifications to contracts already in train and how the procurement regime affects and applies to that. Probably fair to say that this is an area of procurement law which has a somewhat checkered and troubled history to it. There are whole aspects of it which have never really been terribly clear. That was something which I think it's fair to say they were hoping would be cleared up or largely cleared up with the advent of Regulation 72 in the public contracts regulations in 2015 when those were implemented. That I think it hasn't actually happened. There is still quite a lot of lack of clarity around some of this, some aspects of this area. Not least because there are still, frankly, omissions which even the case law, which ordinarily might sort of go some way to plugging some of the gaps, hasn't completely addressed. And oddly enough, we haven't really seen that much in the way of cases on complaints, challenges to modifications to public contracts, on the basis, for example, that a modification, a variation which purports to be relying on Regulation 72 doesn't do so. It's been strangely quiet, notwithstanding perhaps the lack of clarity that we've seen. Now, this area of procurement law all really, I suppose, had its genesis in the press text case a lot of years ago now, an Austrian case. And that case started laying out some of the core principles around procurement law and contract variations, which have found their way through into Regulation 72, but which, as we'll see later on, only actually account for a fairly small part of what is now Regulation 72. So Regulation 72 then built on the press text principles and applied a generous amount of gold plating, a lot of extra content, if you like, building on the principles originally given by the press text case. So how does it do that? How does Regulation 72 actually work? Well, it works by setting out 6 circumstances. Now, these are often called safe harbors for reasons which we'll see, where circumstances in which a public contract can be safely varied, safely modified, so as not to require a fresh competitive tender process. The rule is that where a modification falls outside one of those 6 safe harbors, it's to be regarded as a new contract, therefore essentially requiring a new public procurement procedure. So where one of the safe harbors doesn't apply or isn't available, so in all other modification cases, a new procurement is going to be required, and that specifically is a provision in itself. That's Regulation 72(9). So this is why they're called safe harbors, because in order to not have to do a fresh procurement process on a modification, you need to be within one of the safe harbors. There are a set of specific carve-outs which mean that no new procurement is necessary. In this session, I'm going to be presenting each safe harbor. So I'm going to be describing what the safe harbor actually says and giving you some observations, some of our observations on each one. I'm also going to be explaining a bit around what Regulation 72 doesn't do, as well as what it does. And we'll be describing some typical variation situations which Regulation 72 doesn't really tackle head on. So those are situations where basically we get asked to do a lot of our advice, because client authorities look at the regulation and say, well, yeah, that doesn't really help in this situation. What do you think? So we'll be thinking of some of that as well. I'm going to be at the end of this session giving you just a minute or two on the current status, an update on the current status of the Procurement Bill. And if time allows, which hopefully it will today, I'll pick up on any questions that you might have. So if you do have any questions, please drop them to me in the Q&A box of the webinar, and I'll select one or two of those and pick them up if we've time. If we haven't time, don't worry. It would be my intention to respond individually to each one offline in any event, as we've done previously. So, embarking on the 6 safe harbors, and the first of the 6, we start with Regulation 72(1)A, and this this gives us a safe harbor, so no new procurement required, where we've got modifications which, irrespective of their monetary value, have been provided for in the initial procurement documents in clear, precise, and unequivocal review clauses, which might include price revision clauses or options, provided that such clauses do both of the following 2 things. It's not just one or the other, it's both. They've got to do both. State the scope and nature of the possible modifications or options, as well as the conditions under which they may be used. And secondly, don't provide for modifications or options which, even if they're all there and set out and clear and precise, would alter the overall nature of the contract or the framework agreement in question. Now, you'll have noticed that I'm using red font for some of this, and this is emphasis. It's where I'm basically picking aspects of the regulation out and expanding or expatiating a bit upon them. So I'm using red for that purpose throughout this session. So, okay, provided for in the initial procurement documents. So this presupposes, or appears to presuppose, that the contract that we want to modify with our clear, precise, and unequivocal review clauses had its origin in a public procurement process, because the regulation supposes that there were initial procurement documents. What if there weren't? So what if there wasn't actually an initial competitive procurement process? What if the contract that we're now seeking to modify had its origins, for example, in a direct award or in a transparency notice followed by a direct award? That's a question which, as far as we know, hasn't ever really been answered in procurement case law or otherwise. That's the first observation. The second one is exercising a pre-existing option, for example, an option to extend an existing contract, really even a modification at all, if we have a contract which has always had in it an option to extend, for example, at the end of year 3 for a further 2 years. Is that really even, are we even changing that contract? Are we simply doing something which the contract as it stands already allows? Is it actually a modification at all? Well, that perhaps is an arguable point. Maybe the argument that says that is a modification is the fact that Regulation 72(1)A appears to regard it as a modification by saying which may include price revision clauses or options. So maybe perhaps Regulation 72(1)A does regard a pre-existing option to extend as a modification, bringing us therefore within the scope of Regulation 72(1)A and meaning that Lim 2 has to apply, and our option to extend can't provide for modifications which would alter the overall nature of the contract. Otherwise, we fall outside, even despite the pre-existing option. Perhaps then we fall outside the safe harbor. So it's an arguable point, but it's perhaps one to be aware of. Point number 3 on here: if so, is an existing option to extend the term, let's say, to twice the length of the current contract, sufficient to alter the overall nature? And again, we're not really, I don't think anyone can really be totally clear on that. Does that alter the overall nature of the contract? Good question. As I've already said, and this is point 4 here, note the twin requirements for the review clauses. They have to hit both little 1 and little 2 in order for it to be okay. And finally, the bit about the red section in bold italics. I've already alluded to this, but just to reiterate, what if there wasn't actually an initial competitive procurement in the first place? Sometimes, for example, it happened a lot in the pandemic, where a lot of contracts that had to be directly awarded to start with and then modified to cope with changes brought about as the pandemic dragged on. So, we might perhaps affectionately call this a 72 on top of a 32 situation, or a modification on top of a direct award situation. Regulation 32 of the PCRs being, of course, the provision which allows direct awards in certain circumstances. So where that situation applies, does that simply rule out this safe harbor on a whim? Under the existing regime, that's a difficult question. We'll be seeing in November that might actually be an easier question to answer under the new regime when the procurement bill is enacted. But more on that later if time, and definitely in November. Second safe harbor then. contracts may be modified. This is in Regulation 72(1)(b). So 72(1)(b) is where we need to modify the contract to introduce additional work services supplies from the original contractor, which have become necessary. Okay, first point there, and were not included in the initial procurement. Okay, so maybe this red bit kind of perhaps starts to beg similar questions. But where a change of contractor, first of all, can't be made for economic or technical reasons, such as, so a non-exhaustive list, such as requirements of interchangeability or interoperability with existing equipment, services, or installations procured under the initial procurement. So again, potentially a Regulation 72 on top of the 32 question coming through here again. And by the way, this is an and. It was mistakenly transposed from the directive as or in the PCRs in 2015, but then that was corrected by amending regulations shortly afterwards. So it's now and would cause significant inconvenience or substantial duplication of costs. So either significant inconvenience or substantial duplication of costs. I suspect that if it did both, that would still be within 2. Big caveat to this one. In order to enjoy this safe harbor, any price increase, any contract value increase or increment mustn't exceed 50% of the value of the original contract. So some observations on this one then. First of all, if we are to rely for purpose of particular modification on this safe harbor, 72(1)(b), then unlike 72(1)(a), we need to publish a modification notice in Find a Tender. Now, there is no prescribed timing requirement for when we need to do that under the regulation, but best practice would certainly dictate that we ought to treat them like contract award notices. And in fact, for transparency's sake, it probably makes eminent sense to do both together and to post within 30 days after the variation takes effect. Now, we would normally recommend also publishing a contract award notice alongside a modification notice. Now, you might be thinking, well, why on earth would we need to do that? The reason is it's because of Regulation 93(3) of the Public Contracts Regulations, which specifically deals with managing the risk of contract ineffectiveness. And if you take as a premise the fact that ineffectiveness on an illegal modification might be a risk, as well as being a risk in relation to an illegal direct award, Regulation 93 deals with the way in which contract award notices, or Regulation 93(3) deals with the way in which contract award notices can be used to head off ineffectiveness risk. And Regulation 93(3) speaks of relevant contract award notices as notices which can address and mitigate against ineffectiveness risk. So why publish a contract award notice on a modification as well as a modification notice? It is specifically so that we can say that we have in place a relevant contract award notice specifically to deal with ineffectiveness risk. Now, we've never seen any attempt at a legal challenge on a modification claiming ineffectiveness on the basis of there not being a relevant contract award notice. So it's belt and braces, but it might happen. And where we're talking of 2 notices, we would say ordinarily that the 2 may as well go out together. So the bit about the initial procurement, again in the bold italics, What if there wasn't actually an initial competitive procurement? So the 72 on top of a direct award situation, that comes up here again. Does it simply rule this safe harbor out? Again, we don't know. And again, we look forward to the enactment of the Procurement Bill, which, as we'll see in November, may actually help us in that situation by clarifying that. Third safe harbor then, 72(1)(c). This safe harbor applies where all of the following conditions are fulfilled. First of all, we need to do a modification. We need to vary the contract because there are circumstances which a diligent contracting authority could not have foreseen. Secondly, the modification doesn't alter the overall nature of the contract, so an echo there from previous. And thirdly, any increase in price, again, echoing 72(1)(b), doesn't exceed 50% of the value of the original contract or framework. Now, some observations on this, picking up the first red point. Foreseeability is measured objectively. This is not just a situation which, or a set of circumstances which this particular contracting authority couldn't have foreseen. It goes wider than that. It's an objectively measurable criterion. We have to look at whether or not a diligent contracting authority could have foreseen it. And therefore ask ourselves, even if this particular contracting authority or the contracting authority faced with having to do the modification couldn't have foreseen it, could a diligent contracting authority on an objective level have foreseen it? Same considerations are in play around overall nature, not altering the overall nature of the contract. And that's a sort of a recurring theme really throughout Regulation 72. Urgency is not specifically cited as a requirement or feature of 72(1)(c), so urgency specifically. We can contrast that with Regulation 32(2)(c), which deals with cases of direct awards of new contracts in situations of extreme urgency, which are brought about by circumstances which are neither attributable to the contracting authority nor foreseeable by it. And again, there's complication there because Regulation 32(2)(c) for direct awards isn't objective, whereas Regulation 72(1)(c) does apply an objective standard, a diligent contracting authority, rather than merely this contracting authority. So there's an odd contrast between the two here. Fourth issue here, and I suppose this is a question, again, an unanswered question in terms of case law, I think. What's the relevant point in time for the non-foreseeability? Is it the time the contract was first signed? So at what point, at what stage does the need for the modification have to not have been foreseeable by a diligent contracting authority? What if, for example, the need for the change wasn't foreseeable back when the contract was signed, but the authority did subsequently realize that the need for a change would come about, but has still spent months and months deliberating on it and not got round to making it? What's the situation then? Does it taint the applicability of the safe harbor? We don't really know, and 72(1)(c) doesn't really tell us. So there might be a bit of a judgment call to be made around that, or perhaps a risk-based analysis, risk-based advice given in that situation. So, fourth safe harbor, contracts may be modified here in accordance with Regulation 72(1)(d). And this is where a new contractor replaces the contractor to whom the authority had initially awarded the contract, and where the change of contractor comes about as a consequence of one or the other of two things. So not both here. This is not an and, this is very definitely an or. First of all, an unequivocal review clause or option in conformity with Regulation 72(1)A. So where you've got your clear, precise, and unequivocal review clause, which from the start envisages the advent of a new contractor and sets out, in accordance with 72(1)A, the circumstances in which, the conditions under which that clause can be invoked, and hits all those boxes in 72(1)A, that's okay. Or, as obviously very often happens, there is universal or partial succession into the position of the initial contractor following corporate restructuring, including, so this is a non-exhaustive list, it's an open list rather than a closed one, takeover, merger, acquisition, or insolvency of, actually that probably would be better if it actually said by rather than of, but the directive said of, so the regulations say of, another economic operator that fulfills the criteria, so this is where it starts getting interesting, fulfills the criteria for qualitative selection initially established, provided this doesn't entail other substantial modifications to the contract and is not aimed at circumventing the application of the PCR. So in D, there's quite a lot of interesting stuff going on, so swilling around here. As we'll see, it gets really quite interesting. First of all, the list of succession events, okay, as I've already pointed out, isn't actually closed, it's an open list. So obviously there is a general guide in that red wording into above, but it's actually an open list. So it's corporate restructuring, including, so it's any kind of corporate restructuring, including but not presumably limited to takeover, merger, acquisition, or insolvency by, we should say, another economic operator. So there is obviously an anti-avoidance provision which has to be heeded. Next question, okay, what about a share purchase, for example, of a contractor rather than purchase of assets, undertaking, goodwill, etc.? So a share purchase presumably means that the actual contractor will remain the contractor. It's just the ownership of that contractor will change. And again, there is potentially some analysis to be done in that situation around whether or not Regulation 72(1)D is actually being, actually applies. So, for example, I mean, one might have to look here at whether or not a contractor in whom the shares have changed hands fulfills, or some or all of the shares have changed hands, whether this is a universal or partial succession, for example, whether the contractor then continues to fulfill the criteria for qualitative selection. So one might need to look back at how its suitability was measured back at the pre-qualification stage, and that, of course, in turn presupposes that there was an initial procurement during which the criteria for qualitative selection were indeed assessed. And this brings us to point 3 here. What if there wasn't an initial procurement, so there weren't any original selection criteria? There wasn't a pre-qualification stage, there wasn't an SQ selection questionnaire. Does this again mean that we simply can't we simply can't rely on this safe harbor at all, or does it not mean that? And again, this is something which hopefully is going to be clarified in the future. And the fifth safe harbor: modifications allowed without a fresh procurement where Regulation 72(1)(e) applies. And this is perhaps maybe the most interesting safe harbor of them all, because this actually is the one that basically codifies the press text decision from all those years ago. So it's almost as if the press text decision is kind of started off as a little village, which has now become subsumed into a much bigger city. So press text really is sort of preserved in 72(1)(e). So all of the rest of 72 is kind of padding that's all been built up around it. So 72(1)(e) applies where the modifications that we want to make, irrespective of their value, okay, that potentially is quite handy, that feels generous, are not substantial within the meaning of paragraph 8. So the first point about 72(1)(e) is that it goes hand in hand with 72(8). So in my advice, whenever I'm advising on 72(1)(e), I always say 72(1)(e) / 72(8), because really the two have to be read hand in hand. A modification will, now this is where it gets a little bit confusing, because it then flips to where the modification that we're looking at will be substantial. So it has to not hit any one of the following, because if it does hit any one or more of the following, it will be substantial. So it has to not hit any in order not to be substantial for the purposes of 72(1)(e). So will be substantial, says 72(8), where one or more of the following conditions is met. First of all, the modification renders the contract or the framework agreement materially different in character from the one initially concluded. So this, again, is a little bit confusing, because here the language used is materially different in character. If we think back to 72(1)(a) and (c), there, in those regulations, we were talking about altering the overall nature. So is materially different in character the same as altering the overall nature, or is it not? Are these points, little sort of, causes for confusion that perhaps we might want the procurement bill to pick up and correct for us, or to clarify for us? So there's a question around that. Secondly, the modification introduces conditions which, had they been part of the initial procurement procedure, so you can see again here what's coming. What if there wasn't an initial procurement procedure? Would have allowed for the admission of other candidates, so would have altered the bidder lineup. 2, allowed for the acceptance of a different tender, so allowed to somebody else winning, or, and again that's an or and not an and, attracted additional participants to the procurement procedure. Okay, so so there is a series of, within that there are a series of alternative scenarios which could apply and would render the modification substantial. Thirdly, modification changes the economic balance of the contract or the framework agreement in favor of the contractor in a manner which wasn't initially provided for in the initial contract or framework. So that's, I suppose, tantamount to making the contract, maybe on a sort of a macro level, a better deal all round for the contractor than it had started off. Fourthly, modification extends the scope of the contract or framework considerably. What exactly is the scope Well, again, that might be something which the bill, when it comes into law, will start to clarify for us. Considerably, what does that mean? Okay. And finally, fifth one in the list, a new contractor replaces the one to which the contracting authority had initially awarded the contract in cases other than those provided for in 72(1)(d), right? So whenever we fall outside that open list in 72(1)(d), we're potentially into substantial modification territory. So there's quite a bit of navigation to be done around that in order to work out whether, if we've got an accession, it's within 72(1)(d, or whether it's a substantial modification, therefore knocking out 72(1)(e). Right. So some observations on 72(1)(e), and obviously I've gone over onto a second slide for this because there's quite a lot to say. First of all, if any one of the situations in 2 on the previous slide, in indent 2 on the previous slide applies, then the variation will be substantial. And this safe harbor simply won't be available. Another safe harbor, of course, might, in which case, great, but this one won't. Again, second point here, is this safe harbor unavailable if there wasn't an initial procurement procedure? 72 on top of 32, that recurring theme. Thirdly, what about the economic balance shift? Can a variation still be substantial if it shifts the economic balance away from the contractor and towards the contracting authority? What if it makes the contract a worse deal, as variations quite often do, for the contractor, and a better deal for the contracting authority? The answer is yes, because it could, depending on what the modification is, could, I suppose, have affected the outcome had it been a feature of the original procurement. It might have led, for example, to the materiality factor in 72(1)(e), sorry, 72(8)(1), that first one applying. In other words, it could have led to to more or other tenderers or to a different winner. So it's a question of having to look at the modification in question and working that out. Also, we have some case law post-dating, some EU case law post-dating the PCRs, which confirm, in fact, that modifications which are a result of dispute settlements can be substantial. That's worth knowing as well. What does considerably mean in indent 4, where 72(8) talks of altering the scope of a contract considerably? And in applying indent 5, this is the succession of another economic operator in circumstances other than those provided for by 72(1)(d), should we apply the wider range of events? Remember that list in 72(1)(d) isn't an exhaustive list. So how do we square this away with the fact that the list of events in 72(1)(d) isn't exhaustive? Should we interpret this by reference to the potentially wider range of accession events than the specific ones picked out expressly in 72(1)(d)? I suspect the answer is we should give it its wider interpretation. And finally, on this, as I've already noted, this actually is the limb of, it's the one limb of Regulation 72 which goes nearest to actually codifying the principles originally developed all those years ago by the press text case in the European Court of Justice. Okay, sixth safe harbor, sixth modification safe harbor, 72(1)(f. And again, this is one which goes hand in hand with another part of Regulation 72, i.e. 72(5). So in my advice, when I'm referring to this, I tend to write Regulation 72(1)(f) stroke 72(5). And this basically is what we might call a de minimis modification provision, really. So 72 applies when we're dealing with really small modifications. And this applies by value. So it applies where the value of the modification is below both, not just one, but it has to be below both of the following values. First of all, the relevant threshold mentioned in Regulation 5. So that's the procurement threshold for works, services, central or local, or central or subcentral authorities, or light touch services, or supplies, central or subcentral. So the relevant procurement threshold for the contract in question. And below 10% of the initial contract value for service and supply contracts, and below 15% of the initial contract value for works contracts. So here we have to sort of track through, which of those sort of baseline thresholds we're dealing with, and work out which, whether we're central or subcentral, and whether we're works, supplies, services, and it's 10% if it's supplies and services and 15% if it's works. All of that, however, is subject to our recurring sort of leitmotif, if you like, which is that once again, yet again, the modification that we are dealing with can't alter the overall nature of the contract or the framework. Now, you might have thought that actually, if it's a de minimis modification in terms of its value, it probably shouldn't alter the overall nature. Perhaps ought to stand to reason that it wouldn't, but you just never know, because of course you have to look at subject matter, scope, and so on and so forth. If you're swapping a contract with completely different services or supplies, for example, then it might. So you can never really rule it out. But perhaps the risk of a de minimis modification actually altering the overall nature and scope, or overall nature, should I say, for this purpose of this, are probably fairly small, we ought to think. Okay, so what are my observations? Well, first of all, the de minimis safe harbor it ought to be seen perhaps as a relative breath of fresh air after the complexities of some of the other safe harbors. But remember, as I've said already, that the value uplift has to be below both of these figures. So it's a double baseline, if you like. I have seen a number of occasions where authorities are a little bit confused and thought it's only one. It's not, it's both. So, having been through all of those safe harbors and left you hopefully with some interesting observations on them, just a few other points on this. So, these, I suppose, are cross-cutting points. First of all, the rule for the reckoning the value shift on successive modifications. So, Reg 72 doesn't just set out the 6 safe harbors and then move on to Reg 73. There's a bit more to Reg 72 yet. 72.2, for a start, the 50% uplift ceiling applies to the value of each modification. Successive modifications, so if a contracting authority is thinking for a moment of making a whole lot of mini modifications for the purposes of getting round the PCRs of the need for new procurement, then think again, because 72.2 prohibits that. 72 gives us specific carve-outs. Unless the modification is covered, a new procurement will be required, and that's Regulation 72.9. in order to protect against risk around modifications, we would generally tend to say, consider, at least think about the use of voluntary ex-ante transparency notices, or VET notices as they're sometimes known, as a tactical alternative to contract award notices, as I mentioned back at the start of the webinar. However, contract award notices might be preferable where, at least where 72(1)(b) or 72(1)(c) operates because of Regulation 93.3. If in doubt, come and get more advice on that, because it's a bit of a complicated area. However, if we are thinking of using a transparency notice of any sort to deal with any perceived risk of challenge on to a modification, for example, a claim for ineffectiveness as a result of making a modification, we have to remember that they have to contain sufficient detail to alert their readers to what's actually happening, to the true nature of what's going on. We can't simply use them as a fudge or as a way of winging it and hoping that challenge risk will go away. They don't really work like that. Have a look at the Fastweb case, and more recently, have a look at the Faraday against West Berkshire Council case for some salutary lessons on that. Now, the relationship between modification notices, this is where 72(1)(b) or C applies, on the one hand, and VETs and CANs on the other, contra award notices on the other, has never been particularly clear. And what I mean by that is there's no express timing requirement for the publication of mod notices, unlike VETs, which have to be published in order to do what they're intended to, at least 10 days prior to award, and contract award notices, which can and must be published up to 30 days after award. Now, VETs and CANs, for transparency purposes, are both basically intended to do the same thing, or a very similar thing. They operate in slightly different ways. You should never need both a voluntary transparency notice and a contract award notice in relation to the same award. It's really a choice of one or the other, but depending on the precise set of circumstances, there can be advantages or disadvantages to one or the other. Do authorities ever try to, well, fudge it with VETs and contract award notices? Well, yes, I'm sure. We often see voluntary transparency notices issued for variations as well as modification notices. Do modifications, perhaps modifications that don't fall squarely within one of the safe harbors, ever, are they ever done? Do they ever fall under the radar? Do they ever escape legal challenge by virtue of the fact that they've happened under the radar? Well, of course, I'm sure they do. But we just have to be aware, I think, of the fact that Regulation 72 is quite prescriptive. It specifically operates by giving us safe harbors, and we have to remember what the risks are if technically our contract, the variation, doesn't fall within all the safe harbors. The same rules apply to variations to call-off contracts under frameworks, and analogous rules apply where the contract terms which are provided by a framework are then modified before a call-off contract is awarded. So we have to obviously bear in mind, bear all that in mind. Similar rules, now not technically Regulation 72, but obviously rules along very, very similar lines, also apply where terms are substantially altered with the preferred bidder in a procurement prior to the contract actually being signed at the end of the procurement, and also during a procurement which is in mid process, but before a winner is selected. So there are similar rules, the rules which are similar in effect, I suppose, but obviously not as complex, tend to be founded on case law at the moment. I think the bill is going to alter that. But are kind of similar in principle to the ones we see around Regulation 72. So be careful with those as well. In the Procurement Bill, which will pick up, as I said, more in November than now, there actually be 2 sections rather than 1. At the moment, it's Regulation 72 dealing with contract modifications. In the Procurement Bill, we have Section 31, Clause 31, modification of competitively procured contracts during the procurement procedure. Okay, so that will introduce a system of regulation of changes at a point in the procurement which aren't specifically covered at the moment. And Section 69, Clause 69 of the bill, modification of contracts which are in course. This will introduce a new concept of convertible contracts, that is, contracts which weren't or didn't start off as public contracts, maybe because they were perhaps below the threshold, but will become public contracts as a result of the modification that is made. And again, that fills a gap which is currently there. Section 69 is broadly, or Clause 69 as it currently stands in the bill, is broadly aligned with Regulation 72. The ordering is rather different. It's also Schedule 8, which sets out lots of sets of circumstances which are effective, I suppose, essentially the safe harbors. Their ordering is different and more logical, and there are also other subtle differences and additions. So, for example, the need to make modifications for the preservation of life. I'm sure that's come about as a result of the pandemic. More on that, though, in our November sessions, where we're going to be majoring much more heavily on the bill, and that'll pick up the proposed rules on modifications to contracts. Just on the bill, then, the current status of the bill is that it is at committee stage in House of Lords. As far as I'm aware, that stage is supposed to be ending, if not today, at least now very soon. Then it'll move on to the report stage and third reading of House of Lords. Then it's going to start its passage through the House of Commons. Now, there are a lot of, actually, I think I drafted these slides originally when there were still only a few amendments. Actually, that should say a lot of amendments, because there are now a lot. I think there are about 500 from the government alone made so far during the House of Lords stages. And we have to look at the Keeling schedules, which are on the gov.uk website, the Procurement Bill page, if we want to see them in context of the proposed Act and its schedules. Timeline, well, it's as well that we've majored on Reg 72 today, because for the moment, and possibly for maybe up to another year or so, Reg 72 is still going to represent the law on modifications. The bill won't be enacted until probably mid to late 2023, and we're still not certain on precisely the timing. However, there will be 6-month notice given before the Act comes into force. Now, with that, we were going to, I was going to go to the Q&A. I can see that there have been questions dropped into the Q&A box as we've been going along. We've only a couple of minutes left now. So in fact, what I'm probably going to do for the sake of time is to tackle the questions offline. Hopefully that is okay, but we'll get round to answering those pretty quickly afterwards. So on that basis, I think I'm going to say cheerio now. Obviously, if you've got questions for me which occur to you after the session, just please drop those to us or to me. You can see my email address on the website, or get in contact. And again, we'll pick those up separately afterwards. So thanks very much indeed for attending, everyone. And I hope to see you all again very, very soon. And do please sign up if you haven't already to our November sessions, because I'm sure you'll find them stimulating and enjoyable, and hopefully not too boring, given the fact that we are actually thinking of devoting a goodly chunk of each to the procurement bill. That is 8th of November in Birmingham, 15th of November in London. Hope to see as many of you as possible there very soon. Thanks very much indeed, and bye for now.